A prospectus is provided for in Section 2 of the Companies Act. And this is any notice, circular, advertisement, or other invitation offering to the public for subscription or purchase of any shares or debentures of a company. It enables the public to know what a specific company is doing, how well it's doing, who are its directors, who are its auditors, how have they been audited, what are the audit results for the last maybe 3 years. And why do we issue a prospectus? It's to invite the public. Remember, the other two had intermediaries, but now this one is you lay yourself out there and you are scrutinized. The public comes, picks out and sees whether are they interested. Are you giving them something they may want to deal with? Are you inviting enough for them to invest their money with you? And you must remember, the Companies Act is very clear. Whatever information you put on this prospectus must be true. Because people will rely on this document to make a financial decision. So they need to be protected. You're not allowed to quote your intentions without any basis of supporting them. We can have a company and we believe we have a very good future in front of us. But what do we have to support that future that we are saying we have? You see, we can only rely on what has been done before. Have we been audited? Yes. Have we been given a clean audit? Yes. Have we provided the financial reports for the last 3 years? Are we making profits? Yes. And what does our company do? We may be selling houses. We may be buying land. And whatever we are putting in that prospectus, it must be true. So what are the characteristics of our prospectus? So before we go to the characteristics, what are the legal requirements of our prospectus? One, prospectus can only be issued after the incorporation of the company. You cannot issue a prospectus if a company does not exist. Promoters are not allowed to issue a prospectus. We talked about promoters and their role in the formation of the company. So the only time a document will be available to the public is once the memorandum has been taken to the registrar, all the prescribed forms have been filled, taken to the registrar, the requirements of the Companies Act have been complied with, the registrar is okay with your memorandum, with your articles, the name is approved, then you proceed and form a company. That is the only time you can issue that prospectus. So the particulars of the prospectus must contain everything listed in the Companies Act. And again, we said the reason we follow the law is to protect the investors. We also have a date. The prospectus must be dated, and this is considered to be the date of publication unless otherwise proved. So once it's ready to go out there to the public, that is the date that will be relied on. We have the signature. You remember in this prospectus, we have said that we are listing who is the director, who is doing what. So if you are listed there, you must have your signature appended there. So for every application form, a copy of the prospectus must be attached, except application forms issued with a bona fide invitation to enter into an underwriting agreement or application forms issued to existing members and debenture holders. So why do we have a copy of the prospectus with the application form? You remember we were talking about ignorance of the law being no defense. So if you're applying for shares before the allotment, you need to understand what you're doing. So if you're given a copy of this prospectus that has all the particulars of the company, you're expected to read, make an informed decision, then fill in your application and submit it to see how many shares you can get. Section 45 provides for the liability of an untrue statement. We've talked about that copy of the prospectus being availed. So what happens when the directors have listed something which they know and they believe is untrue? So the Companies Act states the term untrue in connection shall be deemed, this is something that is misleading in the form and context with which it is included. And it's not only a false statement, but anything that produces a wrong impression. It also talks about concealment of a material fact. What we talked about, we may form a company that we believe will be very profitable in future. Yet we have nothing to support this belief. We only think that if we get money, we will be able to expand our operations. So if we put down in that prospectus that by 2024, and we're in the company of building houses, and we indicate that by 2027, we will have built houses on various lands that we may acquire or that we have acquired. So when an investor decides to rely on that to join our company, we'll have misled them. And the impression, we may say that we never said we have the land. But when we say in 2027, we will have built maybe 100 houses, that element of misleading, because you can't build houses on air. So the assumption is you have you have already acquired the land. What is remaining is these funds that you're raising to build these houses. So we have and the laws of contract will apply. Willing buyer, willing seller, consideration. So when you mislead someone, and we have the element, is it fraudulent or is it innocent? So fraudulent misrepresentation is what we have said, that by 2027 we'll build land. We've done it knowingly and without belief in its truth, because if we don't have money, how will you be able to do this? In an innocent misrepresentation, you make it honestly, believing what was stated to be true. What would be innocent is we have the land, but the 100 houses may not be able to be completed in 2027. Probably they'll be completed in 2028. So you had no intention of misleading this person. You had every right to hope and believe that you would work within the timelines so stated. So in Derivas Peak, the defendants were directors of Plymouth, Davenport, and District, authorized by the statute to run tramways by animal power, or with the consent of the Board of Trade by steam power. So they issued a prospectus indicating that steam power would be used, but the Board of Trade refused its consent. The plaintiffs, on the strength of the representation of the prospectus, had obtained shares in the company. But in the absence of any evidence that the defendants believed the statement to be untrue, The House of Lords held that they had not committed any total deceit. You remember here we talked about an innocent misrepresentation. For this company, they could use either animal power or trade or steam, but where the board refused to give them consent, they had no way of knowing that the board would not give them consent. So they did not fraudulently misrepresent themselves. But as we see in Holdsworth versus City of Glasgow, where there's a fraudulent misrepresentation, the allotee can only get damages, but if he's able to rescind the contract of allotment, he can. So in the first National Reinsurance Company versus Greenfield, Greenfield had applied for 150 shares in the plaintiff company, relying on a prospectus which wrongly named one F as an underwriter. On learning of the error, he asked to have the allotment to him cancelled, but took no other steps until sued by the company 7 months later for a call. The court affirming the decision of the City of London that without rectification of the share register, the defence was not good and that the defendant had lost the right to rescind by laches, that is unreasonable delay. So what we are saying is, if you find out that you bought shares of a company relying on the prospectus, and later on you realize this prospectus was not truthful. So when you follow up to have the allotment letter cancelled or you resign the contract, you must ensure you follow it up to the last date and have the register amended. Undue delay is not acceptable, even if the wrong was done. So that effect of rescission is that the shareholder will be entitled to his money back. And it's normally with interest and to a refund of any expense to which he has been put. So when you rely on a prospectus, you find that you relied on a misrepresentation, you seek to correct this and you cancel that allotment, you'll be entitled to a refund with interest. But you must remember in this case where once you find out the error, make sure you do it within the stipulated time. You don't hold on to it until the company calls you to make good the shares you have bought, because in that case, you lose out. You're not able to gain anything. So which people are liable for untrue statement in these prospectus? Every person who's a director at the issue of the prospectus, and any person who has authorized himself to be named and is named in the prospectus as a director or having agreed to become a director, the promoters, and anyone who has authorized the issue of prospectuses. So you remember we said your name is there, you've signed by it. So when there is a misstatement, you are liable personally and collectively. So to what extent? There is civil liability, and you are compelled to pay for any loss or damage which the person suffers from the purchase of any shares on this basis of untrue statements. So we also have criminal liability. That is civil liability, whereby damages are given to the person who suffered. So for criminal liability, any person, and that is section 46(1), every person who has authorized the issue of that prospectus will be punished with imprisonment and a fine, or both, that will be determined by the court. We also have liability under the law of fraud. You remember, it's a contract between the company and the shareholder. And if you take action under the general law of fraud, when a person is induced to enter into a contract, he's entitled to rescind that contract and get compensation, where you, as the aggrieved shareholder, you show that, one, there was a fraudulent misrepresentation. Two, you relied on that and there was material facts, and you've actually been deceived. So when you go the contract way, that liability under the law of fraud, you must remember you will show how you relied on that statement that led you to losing money, or that led you to losing out on what you assumed would be done.